Was added to the agenda, I take it.
Was added to the agenda. Let me just go ahead and add everything in the commission. It was supposed to be added because there's some things that need to be added. Okay, clerk, you'll just read the caption, I guess, and then we can get.
Knox County Commission agrees to the following proposal to the county law director to present to Jack McElroy, Knoxville News Sentinel, and his attorneys.
Okay, Commissioner Harmon, you want to explain?
Yes, I do. At the intergovernmental meeting, our law director presented a very thorough analysis of the matter that came before us. That very day we were having our committee meetings, we were presented with a proposal by the law firm of Hollow & Hollow, and it is for Jack McElroy and his Tennessee Open Meetings lawsuit. And there was active discussion, and several good points were raised. And I thought, how can I write a resolution that addresses those points and gets us to the point where we all can be happy with it? I thought the only way we can do this is really what the lawyers call the functional equivalent of, I suppose, a consent agreement. That is, I know a number of commissioners said we don't want to admit to violating anything, but at the same time we want to avoid the cost, the public ridicule, all of the and we need quick resolution of this. So my thought was, why don't we admit no violation, but also agree to the terms that the News Sentinel said for the equivalent of a do-over. Okay? And that furthermore, we clarify that those persons who were appointed at our January 31st meeting are de facto office holders, just as the actions of previous county commission with term-limited persons on him amounted to a de facto government. This, of course, no matter how we handle this, presents a nightmare associated with voting privileges. And I suggest we resolve that nightmare simply by saying that we interpret the charter provision saying that replacements are by the remaining commissioners to mean those 11 commissioners who were neither appointed on the 31st or were removed from this body because of term limits. That actually yields 11 of us who will be voting on this. The second appointment process would start when assuming it works out, when the law director tells us we have reached this agreement with McElroy and his attorneys, and a series of steps where people submit materials. There's a candidate statement period followed by a workshop-style discussion, a vote on the countywide offices, and realizing that a group of 11 and a majority set at 10 is a really high standard. I suggested that if there are votes where we do not achieve that majority, we could move them to the end of the agenda, and then by unanimous consent, and only by unanimous consent, commissioners could actually engage in the sort of, how should we put it, negotiation that should always have occurred in public anyhow. If you like candidate A and I like candidate B in this particular area, maybe we can work out something where we all get a little bit of what we want, but we do it in public. So that was sort of the slate method by which only by unanimous consent we would consider them other than one at a time. And all this would be done in open public meetings, and that we agree to be faithful to the spirit and letter of the Open Meetings Act. I think this is a way out of the mess. I think it is a dignified end to something that has caused us great indignities, and I suggest that we do it. I think this is a reasonable way to answer this matter in a way which faith is resolved and with faith is restored.
Okay. Do you have a motion?
And thus I move to approve this and ask the law director to follow through with our proposal.
Okay. Do we have a second?
Second.
Second by Commissioner Smith. Okay. Discussion. Commissioner Lambert.
I don't see where we have the legal authority commissioners. You know, we live in a country that's governed by laws, and we have to follow the law. And there's a lawsuit, and maybe we're going to have to take this to litigation, but I can see where a judge has the power to remove commissioners, but I don't think we as county commissioners have the power to remove these folks. And I believe that if anybody moved to remove Josh Jordan or Richard Cade or Lee Rimmel, that they would have a very good case to be able to sue us because we don't have the legal authority to remove them. And now I understand some folks didn't like the way the appointment process worked. Quite frankly, I wish they would have let the old folks serve until we could have an election. or that we could have had some sort of a special election. But unfortunately, we had to make the appointments, and unfortunately, the News Sentinel sees some fault with the process, and they've sued us. Well, this has got to go into litigation. We can't just sit down in a country of laws and decide, well, we're just going to throw the law books out the window and we're going to throw some folks out of office when we don't have the authority to. I think we need to let the legal process work. I think that's what we've needed to do from the very beginning. And I think that this proposal throws us into more legal trouble than we're already in. Because how do you propose that we throw someone out of office? Because I just don't see where we've got the authority.
May I ask the law director a question? Would not a consent agreement agreed upon before a judge have the legal authority that Commissioner Lambert is exercised about?
In my opinion, it would if it were passed by this body.
Okay, Commissioner Pinkston.
Well, you know, I can't go along with what Mr. Harmon says over there. According to the Supreme Court, it says, according to the court, the county officials who are ineligible to hold office due to term limits may continue as de facto officers until their successors are named in accordance with the law. So in all reality, what Commissioner Harmon is trying to do is go against the Supreme Court's ruling here. He's saying these people shouldn't have voted. All right. The charter says, the Constitution says, vacancies in county offices shall be filled by the county legislative body, and any person so appointed shall serve until a successor is elected at the next election occurring after the vacancy and is qualified. The Knox County Election Commission, the Election Commission cannot conduct a special election to fill these county vacancies. Rather, the Election Commission shall place these county officers on the regular August the 7th, 2008 election ballot. Now, we've appointed these people to serve when we appointed them to 2008, August the 7th. So we're opening ourselves up for a lawsuit there. Now, another thing, Mr. Harmon, I take this very seriously. I'm not like one commissioner thinks we're making a joke of this. I respect our Constitution very much, and when we start chipping away with it, trying to pass laws and circumvent it, we're doing wrong. There's just no way that we're supposed to do that. We've got safeguards to take care of this. The people, we're not taking a vote away from them. They'll have a vote come August the 7th before that. And I resent us sitting up here and trying to circumvent our Constitution. Now, we could say a lot of things up here and do everything, but what are we going to do? Every time something comes up that you don't like, come up with something against the Constitution. Every time something comes up that I don't like, I come up with another law. This is not right. And I don't know who won or lost on this thing. I had nobody from the Sheriff's Department talk to me. I had nobody from the Mayor's office talk to me about these appointments. And I do not feel like myself personally that I've violated any law or I've taken any rights away from any of the people. Now, if you didn't conduct things properly in your district, Mr. Harmon, that's your fault, not the 9th District district's fault.
Mr. Chairman, I was mentioned directly, and I would like a point of personal privilege. This is not about the Constitution of the State of Tennessee or the Constitution of the U.S. We all swore to uphold those. We also swore to uphold our charter. And the laws of the State of Tennessee include an Open Meetings Act. Our law director has advised us that there's a serious possibility we could lose this lawsuit and these things that we have will be declared null and void. Rather than going into it in a manner that we do not like, let us take advantage of the opportunity now to step up and say we can offer this consent agreement where we admit no wrong, where you don't have to admit you did anything wrong in your district or anywhere else, but we get it resolved. And it isn't about who won and who lost, because the public lost. The public lost when we did not do it the right way. Now, the charter that we swore to uphold, and that 5 members of this body sued to invalidate, said that the remaining members of the commission shall fill said vacancies. This is a reasonable interpretation of the law, because if you try to get a second vote now, whether by my resolution or forced by the court, you're entering a legal miasma. Let's look at it. Who has the right to vote? If we declare them de facto commissioners, then the persons whose terms we agreed to serve have ended because their successors are de facto. And a good court can make an argument that those persons who we bring back to vote don't have the right to vote.